Lisa Priest.
Thank you. And for appellees.
Good morning, Your Honor. I'm Nate Hodgkins, and I'm representing the respondent appellee, Lizotte.
Thank you. As I indicated, we are being streamed on the web. And Mr. Lizotte, if you would like to proceed, we'd be happy to hear your arguments.
Thank you very much. I appreciate it. Your Honors, this case resides at a three-way intersection of property law, municipal tax lien foreclosures, and the probate code. At issue on this appeal is whether quitclaim deeds granted by the town of Pembroke in 2005 and 2011 severed the joint tenancy Ms. Priest shared with her since-deceased husband, Brian Priest. The question of whether Ms. Priest holds title to her formal marital residence as a joint tenant or as a tenant in common is a critically important one to her and potentially to other litigants in the probate courts and to potentially come before this court. As a joint tenant, she would have exclusive ownership of the home. Brian Priest died intestate, so she would have acquired his undivided half interest by right of survivorship. By contrast, as a tenant in common, Brian Priest's share of the property is treated as an estate asset, which would be subject to Maine's intestate succession laws. The language of the deeds is critical to this case. Ms. Priest's prior warranty deed expressly conveyed the property to her and to Brian Priest with the familiar language often seen in conveyances to spouses across this state and, to our understanding, jurisdictions nationwide. That language being as joint tenants and not as tenants in common. The town's quitclaim deeds followed tax lien foreclosure proceedings under 36 Maine Revised Statute Section 943. The town's quitclaim deeds did not contain those magic words that were present in the Priest warranty deed. However, following the full payment of the tax liens and costs, the town did issue to the priests the municipal quitclaim deeds as, quote, releases. And those releases, by their terms, were only meant and intended by the town to convey its interests in the property by virtue of its tax liens. So, Your Honors, appellant's arguments here are twofold. The first is that the probate court erred in failing to recognize that the deeds left Ms. Priest's joint tenancy intact. That was the misunderstanding that the probate court proceeded on below, and that was seemingly accepted by Ms. Priest and adopted by counsel below as well. And second, even if the deeds did sever the joint tenancy, the reformation was supported based on the particular language of the deeds themselves and the evidence of record. Ms. Priest's position does align with the approach stated by this court in Palmer v. Flint, that joint tenancies are, quote, looked upon with favor rather than disfavor, and that, quote, deeds, if possible, should be construed as joint tenancies in the entire estate parted with by the grantor. And moreover, severance of a joint tenancy, as we briefed, is primarily an issue to be decided between the joint tenants themselves, rather than by a third party, such as the town of Pembroke here. Ms. Priest requests that the court rule.
Counsel, excuse me, I see that the green light is on.
Yes, sir.
Was there actually a foreclosure in this case, and does that matter?
By operation of law, by operation of 943, Your Honor, we accept that there was the statutory amount of time following the notice of foreclosure based on the record appears to have gone by. However, the record is absent about...
But there's an 18-month redemption period under the statute, correct?
Correct, Your Honor.
And that 18-month redemption period begins when the tax lien is recorded, correct?
Yes, Your Honor.
And it expires 18 months later. If the taxes are repaid during that 18-month period, then there is no foreclosure. Is that correct?
That is correct, Your Honor.
And doesn't the record here show, or at least suggest, that the taxes in each of the two instances, the 2002 and the 2009 instance, were repaid within the 18 months?
Your Honor, the 2005 and the 2009 instance, I believe.
Well, the first tax lien was recorded on September 23rd, 2002. The second tax lien was recorded on October 2nd, 2009. The first in the first case, the taxes were actually paid 17 months and 29 days later. It would appear from the record, anyway, from the deeds and from what I'm looking at, and the second payment for the second tax lien was paid in far less time, maybe 13 months, a little over 13 months. So if that's the case, then all that the town ever possessed or held was a mortgage interest. And a mortgage interest does, in and of itself, doesn't sever joint tenancy, does it?
Uh, it
Counsel,
would,
take the softball question.
I agree with everything Your Honor has just stated. My only hesitation is that the record below, for example, Your Honor, we don't have records of the payments, as far as I can tell,
Counsel,
but
I'm
I
gonna
would agree with that.
Counsel, both attorneys, I would direct you to pages 47 and 48 of the appendix, the quitclaim deeds, both of which reference the date of payment.
March 22nd of 2024. Yes, Your Honor. Yes, thank you, Your Honor. Then, without any caveat or qualification, Your Honor, I agree wholeheartedly with everything that you've just articulated.
So what did the quitclaim deed or whatever it was actually do? Does that function as simply as a discharge of the lien?
Yes, Your Honor, and to more directly answer your question, it did nothing vis-a-vis the joint tenancy. It didn't sever the joint tenancy. It didn't affect any sort of conveyance that would have disrupted the joint tenancy. And that's why appellants' arguments continue to be that the joint tenancy endured and that with it, her right of survivorship endured as well.
Well, if the property actually had been foreclosed under the statute and the town, after the 18-month period, conveyed the property to whomever, your client or whomever, in the form of the deed that was used, that would not have been a conveyance in joint tenancy, would it?
Your Honor, this gets to the arguments briefed by appellant. By operation of this court's Sargent decision and the particular language used in the municipal quitclaim deeds themselves, our position is that the joint tenancy, even following a valid tax foreclosure proceeding, still did survive. And that's because of the distinction.
Of section 943, or because, I mean, the language in the actual deed, the conveying language, does not convey a joint tenancy as written. Do you agree with
that? By the terms of section 159, Your Honor, that is correct.
Okay.
But our position is, reading this court's Sargent opinion, which is lengthy, and admittedly the section cited by appellant is more than likely dicta. Despite that positive law in section 161, for example, the law about quitclaim deeds conveying an estate which the grantor has and can convey, notwithstanding that, the jurisprudence of this court has recognized that there is a carve-out for that. There's a distinction between quitclaim deeds that convey actual land versus quitclaim deeds that convey a right, title, or interest in the land. And under the opinion of this court in Sargent, conveyances of right, title, or interest in land actually do not convey any estate, which is what we've argued in our opening brief and on reply. So even in the scenario where the tax lien foreclosure was validly effective, our position still remains that the joint tenancy endured based on Sargent.
Let me ask
Oops, sorry, go ahead.
A question on an issue that wasn't briefed. This is, if it just conveyed a tenant in common, it destroyed a right to survivorship, which is a property interest, correct?
Yes, Your Honor.
So it has some value.
It does.
So my question is, what is the impact of Tyler versus Hennepin County, the Supreme Court case that says that when the town takes a tax case, takes property via, because they didn't pay their taxes, it cannot keep any more than the amount of the tax that was due, or it's a taking of that excess of what they get when they sell the property. It's a different situation, but it's still destroying a property interest. And under the reasoning of that Supreme Court case, if we said that it destroyed the right of survivorship, would that be a taking?
Your Honor, based on your very astute question, perhaps I should have briefed procedural due process issues, because after submitting the arguments,
This is taking law.
substantive and procedural, there's problems on both fronts, would be our view. And of course, I'll say the pat response that we'd be happy to brief that. But to answer your question directly, the issue with this case, the overarching problem of this case, is that nobody had any idea that this happened until 18 years later.
Well, would the simplest method then to deal with that have been to call people from the town saying, well, we didn't really mean to do that. This just, we weren't trying to change anything. We were trying to give her back what she had.
Your Honor, in a perfect world, yes. But for a pro se litigant like Miss Priest, proceeding without legal training, who did attempt to FOIA records and received nothing, who very likely did not understand her ability to subpoena witnesses, it was, in our view, a prohibitive and likely impossible option.
Counsel, the problem or the conundrum that you cite is a real one. And in fact, the legislature recognized that. And shortly after the last transaction in this case, it amended the statute to provide expressly that a reconveyance from the town back to the original record title holder does not abrogate joint tenancy, right?
That's correct, Your Honor.
So just my question with that backdrop is this: doesn't that undercut your argument that in this case, your construction of Section 943, which the portion which says that when the town reconveys the premises back to the former record title holder, that all the interests of all the others are revived? Obviously, that the legislature didn't think that was the case, that was strong enough, and so they therefore amended the statute to make it express.
Your Honor, the legislature did obviously affect that amendment in Section 159 for cases from January 2012 going forward. So the operative positive law for litigants to operate within obviously would address those scenarios, but it does not address the scenario here where we have two municipal quitclaim deeds that trace back to 2005 and 2011 is our view. So there still is a remedy to be addressed.
Right.
Or harm to be addressed.
Therein lies the problem, because it would appear as if the law as it existed prior to the amendment would not support your position.
In that regard, yes, Your Honor. However, looking at the actual, would I be permitted to finish my thought, Your Honor?
Your thought.
Thank you. Looking at the language of the deeds itself and the context of the releases back to the priests here, there is a sound argument that there was no severance of the joint tenancy to begin with. Thank you, Your Honor.
Thank you. Mr. Hodgkins, we would be happy to hear your argument too. As soon as you appear on the screen there we go.
Good morning, Your Honors, again. May it please the court. Municipal quitclaim deeds conveying land and executed prior to January 1st, 2012 are subject to the exact same rules of construction and general rules of law as any other quitclaim deed conveying land. The quitclaim deed at issue here, or the two quitclaim deeds at issue here, released land in Pembroke, not an abstract right in land, but land itself explicitly to the deceased and the appellant without indicating the type of ownership being transferred. The words joint tenancy were never used. No attendant phrases such as with rights of survivorship were used. On its face, it was unequivocal. The deed transferred the estate, pursuant to the default statute of Title 33, Section 159, which favors tenancy in common, transferred the property to the priests in common. Now, if the deed had been transferred, as the court knows, after January 1st, 2012, everyone agrees it would be subject to the rule adopted by the legislature in 2011 in the final paragraph of Title 33, Section 159, in which case the priest's former title of ownership would have reverted automatically to what it had been prior to foreclosure. The appellant agrees with us, and I think the court agrees, that doesn't apply here. Instead, the appellant relies heavily on Title 36, Section 943. I'm asserting that on its face, that section does not apply at all to the rights of previous owners. Title 36, Section 943 unambiguously revives only those rights held by interest holders prior to foreclosure other than the prior owners. And that's inherent in the statute. It's a tax statute. It's designed to revive those creditors' rights that were sort of swept aside when the town put a tax lien on the property and then completely erased when the town foreclosed. And the town in this case did in fact foreclose, and I can speak to that through the questions. Now our argument is that Title 36, Section 943 is unambiguous. Now, obviously, that's a question for the appellant. If the court were to find that it is ambiguous, I would suggest looking to legislative intent, as the court's already sort of foreshadowed, suggests the exact same outcome here. That the legislature, because they in 2011 modified the final paragraph of Title 33, Section 159, it's obvious that they did not believe that.
Counsel, excuse me, the green light has gone on. So let me ask you this question. You stated, I believe, that there was a foreclosure here. Is there not an 18-month redemption period built into the statute? And if the taxes are repaid during that time, doesn't that foreclose a foreclosure, if you will?
I agree, Your Honor, and I believe that's been addressed by this court more or less in the Schaefer v. People Heritage Savings Bank case, which was an analogous, I'd say an analogous case where you had a mortgage.
So that the only interest the town ever received was a mortgage interest, correct?
Where I disagree, Your Honor, is that the 18-month period did occur. There was a redemption period. They failed to pay within that redemption period. If you look at page 47, you have a tax lien dated September 23rd, paid in full on March 22nd. That's an 18-month period. And this is a quitclaim deed dated June 8th, 2007.
Actually, if you count the days, it's actually 17 months and 29 days. So let me ask you this. What if it were clear? Let's take the second tax lien. That was repaid within 13 or 14 months. Was there a foreclosure there?
I'd suggest, Your Honor, I can't speak to the dates that are here, but what I would say is this. A town, if taxes are repaid within the redemption period, a town does not redeed property back because the town does not have the property at that point.
Well, the town is not supposed to do it that way, but do we know that that's not the normal practice of this town?
We don't know in this case because the town
did things correctly.
Absolutely. I couldn't agree more. The problem is the town, we don't know what the town was thinking in this case. But in normal circumstances, the town does not have the right to the property during the redemption period. They have a contingent right. And if the taxes are paid,
the town used the wrong instrument, didn't they? It should have been a release instead of a deed. It should have been a discharge of the lien. That's effectively what these two documents are. They're
assuming
of the lien, correct? And if that's the case, the town never had title. They had legal title, I suppose, as pursuant to a mortgage, but they never had full title to the property. And in everyday ordinary life, we all have mortgages on our property, presumably. We repay those off. We get the bank doesn't redeed us a new interest in joint tenancy in common. Our joint tenancy stays intact, doesn't it?
Another way of putting it is to say the town had nothing to convey in the quitclaim deeds.
I understand that reasoning, Your Honor, and I can't concede that there wasn't a foreclosure. The fact that there were 2 deeds that were sent back is very indicative of a foreclosure. That's why deeds are issued by towns.
But if the town failed to follow the law with respect to how it resolved the payment of the tax liens prior to the expiration of the redemption period, we're supposed to construe that against the property owner who held a joint tenancy prior to the discharge, or what should have been the discharge of those tax liens?
No, I'm sorry, Your Honor. Can you repeat that question?
Well, what I'm saying is if the town didn't follow the proper procedure that's outlined with respect to dealing with the payment of tax liens prior to the expiration of that redemption period, if you will, we should construe that against the parties who paid off their taxes properly within the specified period, and say that somehow severed the joint tenancy when the town didn't actually have full title to the property as a result of not foreclosing.
No, absolutely not, Your Honor. I don't think it should be held against them at all. I think it should come out at trial to figure out what happened. What is apparent to me from the municipal quitclaim deeds is there was a foreclosure.
Well, let me challenge you a little bit on that, counsel.
Yes.
Although it's titled a quitclaim deed, the language, which other people, earlier in this case thought was a little bit strange. It says simply that it releases the land, and it just simply describes it as land that it was the meaning and intending to convey the town's interest by virtue of a tax lien. It doesn't say by virtue of foreclosure or that the tax lien has ripened in any way. It says by virtue of a tax lien which has now been paid, period. That's all it says. Isn't that really effectively a discharge despite the title quitclaim deed?
I don't think so, no. I think it's a quitclaim deed. But the town could answer that question, and I wish they had.
Okay. Other questions by the panel? Anything further, counsel?
I don't think so, Your Honor. I would like to speak just very briefly, if I could, to the idea of there was a case that was cited by the appellant. I believe it was Sargent v. Coolidge. And I don't think that's where the court's going with this, but I wanted to be clear that the release language, the Sargent v. Coolidge is inapplicable here, because the release language in the granting paragraph of these quitclaim deeds, assuming they are in fact quitclaim deeds and not quasi-releases, as the court is suggesting, grants the release of land, not the release of a right to land. It specifically states releases the land. Now, the appellant has quoted several times in briefs the chain of title paragraph that suggests or says essentially, for source of title, refer to the town's tax lien. That's not the granting paragraph. The granting paragraph very clearly grants land. Now, assuming they're quitclaim deeds, as we've done so far, this grants land.
Counsel, let me ask you this. Assume that we read this as not really a deed in the sense that from the face of it, it appears that it had not ripened into a foreclosure pursuant to Section 943. Let's just assume that for the moment. What is the remedy at that point from our perspective? Do we say, well, it says it, as a matter of law that it hadn't ripened? Do we remand it for new trial? Do we remand it for the court to consider the effect of that? What do we do? Just assume, I know you don't agree that that's the law, but just assume it is. Where does it go?
Of course. I think it would have to be remanded, Your Honor. I think I think what we have and what everybody's been assuming on its face is that we have a municipal quitclaim deed that was granted after foreclosure. Now, if that's not the case, if it was predated by the town, or if the town did something, if there's a clear mistake that wasn't considered in the lower court, then I think it would have to be remanded. I guess that's my answer.
Or would new evidence be taken or remanded for reconsideration on the record already made?
I think
To the discretion of the judge.
I would say the latter, but
Okay.
Well,
Thank you.
what's the relevant evidence? I mean, there's a date, and then there's another date, and then you count the days. So what would be the evidence that would impact that? Why can't we, even though we're an appellate court, count those days if that's the decisive thing? Why do we need a remand?
because it's ambiguous on its face. You have two municipal quitclaim deeds that are only transferred back, that are only executed once there's a foreclosure, which indicates that there was a foreclosure. I understand counting the days leaves you 1 day shy of that, and maybe that's the case, maybe that's the mistake, but somehow there's a mistake there.
Well, the original petition that was before the probate court and is now on appeal was a petition. Well, one of the petitions was a petition to reform the deeds, and that would be mooted, would it not, if we concluded these were not quitclaim deeds at all? They were discharges, and wouldn't, as a matter of law, assuming, as Justice Connors points out, the facts are two different dates. The court could take judicial notice of the number of days that have expired since the recording of the tax liens. That would pretty much determine the issue, wouldn't it?
I think it would, Your Honor. I think it's a huge assumption to assume that the mistake is in the dates when you have actual quitclaim deeds. I mean, one would assume that these are drawn up by attorneys who know the rules of foreclosure, who know that often people pay their taxes after the lien's put on, and it's a simple discharge. Quitclaim deeds are unusual.
Doesn't seem like the town of Pembroke was thinking in those terms all those years.
Again, I can't speak to that at all, Your Honor.
No, I understand.
Well, are we to infer anything from with respect to the fact that the time frame seems much smaller in terms of the filing of the lien claim and the actual payment with respect to the second deed, yet they still gave the same type of instrument to effectuate the termination, if you will, of that lien claim process? Do we infer anything from that?
I'm not sure, Your Honor. Again, I honestly don't know. I don't know where the mistake was.
Anything further from counsel?
No, Your Honors. Thank you.
Thank you. And Mr. Lizotte, I think you reserved 3 minutes for rebuttal.
I did. Thank you, Your Honor. I wanted to briefly respond to several points expressed by the bench during appellee's arguments. First, there's been questions about the lack of a testimonial evidence by the town of Pembroke. And as we argued in our brief, our position remains that the four corners of the municipal quitclaim deeds, such as they've been styled, give the court all the evidence it needs to make this determination. Justice Connors, you asked what evidence would have been offered if this is remanded. Our position is none. The two documents say everything they need to say. Justice Douglas, the timeframes that you've highlighted are present within those four corners, and the obvious nature of this being a release and discharge rather than a true conveyance of land rings out. Justice Horton, I think you hit the nail on the head. The town here truly did have nothing to convey. That's clear under this court's jurisprudence in Sargent. It's clear from the terms of the municipal quitclaims themselves as they're identified, and it's also clear from the import and the interplay between the facts of this case and section 159 and 161. And lastly, Justice Lawrence, to your point, as the court well knows, to construe the statute against the property owner would be a bad thing here. The law requires that we construe it against the taxing authority, which is what the appellant requests here. And if there are no further questions.
To my question, counsel, what does the mandate look like in this case?
I'm very sorry, Your Honor. You broke up at the end of your question.
That to my question, what does the mandate look like in this case? If we agree with that, do we make the determination ourselves that there was no interest to be conveyed because the foreclosure never ripened? Do we remand it to the trial court to make the determination? Do we remand it with the trial court in their discretion to take whatever proceedings consistent with the opinion? What does the mandate look like?
Your Honor, respectfully, option one. This court has a full record before it and is lawfully capable of entering full relief in the favor of Lisa Priest.
But in any event, you want this deed to be either a nullity or simply a discharge of the lien. Is that what you're looking for in a mandate?
I believe the language in prior jurisprudence has been canceled, actually. So I think that would be the terminology we'd be seeking, Your Honor.
Counsel,
But
we don't
still want a discharge of the mortgage, the discharge of the lien, right? On the record.
The discharge of the lien would recognize its validity in the first place.
Counsel, we don't make findings of fact, and the deeds, the instruments do sort of speak for themselves, but wouldn't somebody, some entity, some court need to make a final determination that these payments were made within the redemption period? And my second question, I know we're beyond time here, but there still is an intestate proceeding before the court, for the probate court. So the remand would have to be dovetailed with whatever follows from this appeal.
Your Honor, to your first question, in the record, pages 47 and 48, our view is would settle the fact of when payments were made. The second question, the enduring probate court proceeding, is only as to the personal representative and the winding down of the estate. So our position is no remand would be necessary as to this discrete issue that, in our view, could be carved out from the continuing probate proceedings.
Because you don't think that this estate should be part of the probate proceeding. I understand.
Precisely, Your Honor.
Thank you, counsel. Thank you to both of you. It was an interesting argument, and as is our usual practice, we will be taking the matter under advisement and issue a decision in due course. And with that, I think we're done on this proceeding, and we'll, as a court, we'll reconvene in the courtroom.